Well, hello there. I am live. You're live. Welcome again to our employment law session. My name is Lior Samfiru. I am the employment lawyer. And what I do here once a week, I come on here on social media to answer your questions, about your workplace rights, about your job, about your rights if you lost your job, your rights with vaccinations, if your job has changed, if they've relocated you, you name it, this is the time, this is the place to find out about your rights, to ask questions, and to walk away, hopefully, with answers and solutions. So I'm live. This is a live session, and I'm here taking your questions. You can ask your questions right now. You can see on your screen, there's a little box. You can type in your question, you hit enter. It's going to show up on my screen. I'll read it, I'll answer it, and you'll have that information. So again, for those joining us, I'm the employment lawyer, Lior Samfiru. I'm a partner and founding member of Samfiru Tumarkin LLP. And we operate across Ontario, across BC, and across Alberta. So wherever you are, we pretty much got you covered. So as I'm waiting for your questions, let me give you some other contact information. In case you hear something today that you want to follow up on, or in case you want to have a private chat with me off social media, by phone, by email. So it's very simple. You go to employmentlawyer.ca. You see that on the bottom of the screen, employmentlawyer.ca. It's my firm's website. Not only can you learn a lot about employment law there, you can read about your rights, find out updates on the law, but you can also get my contact information there, and that for everyone on my team. Emails, phone numbers are all there. So if you have questions, you have issues, you have problems, you can reach me there as well. But right now, this moment, I am live here for the next 30 minutes for one reason and one reason only: to take your questions, to answer you. So if you've always wondered about something, maybe it's something that's been going on for a while, your boss has been doing something in the workplace and you're not sure if it's quite right, if it's quite appropriate, why wonder? Just ask the question, I'll tell you, and you will know. And you'll also know what you can do about it. Maybe it's something new. Last week, boss came in and said, we're moving you from 5 days to 3 days. Can they do that? What should you do about it? How can you respond? What your rights are? Ask, I will tell you. A lot of people have questions about vaccines right now. Can your boss require you to be vaccinated? Can they require you to tell them if you've been vaccinated? Ask, I will tell you, and you can walk away with that information. So this is a live session for you. Again, I'm employment lawyer Lior Samfiru. And in between your questions this morning, I'm going to answer some email questions that I've received previously, because I think there's going to be some helpful information there for all of you watching right now. But again, I'm answering your questions. Those take priority, so feel free anytime you're ready to type them in, hit return, and I'll answer them. But as I said, in between your questions, email questions. Actually, you know what? We'll put the email questions on hold for now. I'm going to answer the very first question of the day, and then we'll go back to emails. So first question today from Mandel. Mandel writes, how do I deal with a coworker who is spreading rumors and making a bad work environment? So the first thing you want to do is have a way to show what this worker is doing, because keep in mind, this worker is not going to admit it. So if he's spreading rumors, who is he spreading rumors to? Can you verify that? Is it something in writing? Is it something that people will corroborate? If he's doing a bad work environment, how do we show that? Is it that he's sending emails saying bad things about you, or other people are going to be willing to say that? If you have a way to corroborate it, it's very, very simple. You have to go speak to HR or whoever the right person is in your workplace. And the reason why I say it's simple is once you speak to HR, you tell them I'm being mistreated, I'm being harassed in the workplace, they have a legal obligation. I'm not talking about a moral obligation. They have a legal obligation to investigate and to take measures to fix that problem. They have to, okay? So they must do that. But of course, they're going to want to know, how do we show, how do we prove it? So you have to have something to show for it. Now, if you've spoken with HR, the owner, whoever the right person is there, and they're not doing anything about it, I can get involved in that point. So I can deal with it externally if you're not able to deal with it internally. But in the majority of cases, if you speak to HR, they will have to do something about it. Either it's disciplining this person, letting them go, transferring them, whatever that is, they'll have to do it. So Mandel, by all means, if you're in that situation, let's first be able to show what's happening and then speak to HR. If you have any problems, any issues, feel free to reach out to me off social media. I'd be happy to chat. So thank you for that first question, Mandela, one that I hear often, so I'm glad you asked. Next question from Joanna. My husband got a performance improvement plan until the end of August to improve, but he applied and may get a new job as he feels very stressed. Can he sue the current employer for constructive dismissal after he quits? The answer is no, because it's not a constructive dismissal to put him on a performance improvement plan unless he can show that it's completely bad faith, that it's completely crazy, that they did that just to hurt him. Even if the performance improvement plan is not accurate, you can't take legal action for it. What I say with the performance improvement plan is you have to respond to it. If you don't agree with it, you have to respond to it. Send an email back outlining, here's why I don't agree with it. You say that I've done these things wrong, but here's what actually happened. Here's what you need to know. If you do that, you make it very difficult, almost impossible for the company to let you go, okay? So he can do that, but if he chooses to take another job, which of course is right, he won't be able to take legal action against them because legally they've done nothing wrong. He just has to respond to it if he doesn't agree to it, agree with it, okay? So hopefully that helps you, Anna. Thank you very much for that question. Brian asks, next question. Oh, okay. What's going on with the Uber class action lawsuit? Also wondering if there will be similar class action lawsuits for pizza delivery drivers. So good question, Brian. We were actually in court last week on the Uber class action. So for those that don't know, by the way, my law firm is spearheading a class action lawsuit against Uber, taking the position that the Uber drivers are in fact employees, not independent contractors. And because of that, they have all kinds of rights: vacation pay, overtime pay, holiday pay, termination pay, etc. So we were in court last week for 3 days on what we call a certification motion. In other words, the judge has to decide that the matter has to be certified as a class action, that it's allowed to proceed as a class action. So the hearing was last week. It went well, and now we're waiting for that decision. We don't know when the decision is gonna come out. Probably in a few weeks. Once the court, if we win that and the court certifies it as a class action, then the actual case, the actual merits of the case can proceed. Now, I don't have any information about pizza delivery drivers. I'm not involved in that, but it wouldn't surprise me at some point if we'll see other companies or other industries being involved in these types of lawsuits. So thank you for that question, Brian. Hopefully that answers it. Great questions we're getting today, guys. So you see how easy it is. You type in the question, I read the question, I answer the question. So please take advantage. I'm here live right now with you. Ask your question. I'm going to continue answering them right now, but I want your question as well. So ask it right now, please. Next question today comes from Kevin on Facebook. When severance is given to an employee, can somebody request additional money to be retrained for education? As a long-term employee for many years, can I request more money in case of a layoff? So remember, Kevin, it's not about what you can request. It's about what you're owed, all right? So let me start by saying that in the vast majority of cases, when severance is offered, the employee is actually owed a heck of a lot more than what the employer has offered them. In over 90%, 95% of the cases, whatever you've been offered is a small portion of what you're owed. Maybe you're owed 12 months and have been offered 4 months. But beyond that, yes, an employer also has a legal obligation to participate in any retraining costs that the individual has. So for example, if the only real way for you to find another job is to be retrained, the employer may be liable for those costs, for those expenses. So absolutely, yes. That's why, Kevin, it's so important to get legal advice before you sign off on that paper. Realistically, if you go to your employer and say, hey, pay me more money, they'll say, no, we're not going to do that. We need to push the issue. The nice thing is, once myself or my team get involved, it's easy to resolve quickly in the vast majority of cases. So number one, how much severance, and number two, what's included. It could be bonus, benefits, car allowance, pension, stock options, you name it, all has to be included. including cost of potential retraining. So very, very important, Kevin, but it's not just about you asking, it's about us requiring the employer to pay what they have to pay. So very important, Kevin. And again, for everyone else that wants to connect with me off social media, I've given that before. Let me give it again. Easy. You just go to employmentlawyer.ca. Again, employmentlawyer.ca. You'll see our website there. It has my phone number, my email address, my fax number, and you can reach out to me anytime. So if you don't get your question asked here, or you didn't want to ask your question here, but you want to have a private chat with me, please take advantage. Employmentlawyer.ca. From Linda, Lior, I tried to contact you. I'm a unionized, but have a human rights complaint in WSIB. In most cases, Linda, a unionized employee has to go through the union. If it's a separate human rights complaint, you may be able to do that. I'd have to know more information about it. We don't really deal with WSIB matters here. We deal in issues between employees and employers. But in 98% of the cases, if you're a unionized employee, you can't really deal with a lawyer or hire a lawyer. It has to be the union. But if it's a separate human rights complaint that the union is not dealing with, that has not formed part of a grievance, then you may be able to deal with that with our help. So please do connect with us and we'll find out some more from you. So thank you for that, Linda. Happy to chat. Again, employmentlawyer.ca to do that. Next question from Marie on Facebook. Can an employer let you go while you're on an LTD medical claim? So the answer generally is no, unless the reason they let you go has nothing to do with you being on LTD. So I'll give you an example. Let's say you're off on a disability leave, and in the meantime, the entire department that you work in has shut down and they let everyone go. At that point, if they let you go, there's not much you can do about it, because clearly they're not letting you go because you're on a disability leave. They're letting you go because there's no more department. But unless it's something like that, usually an employer cannot let you go while you're on a disability leave. You continue to be an employee, and when you're ready to come back to work, they have to make all efforts to bring you back if it's possible. Now, if at that point they've looked, they've tried, and there's no job available for you at all, then they can let you go with severance. But generally speaking, it's going to be rare for an employer to let an employee go while they're off on a disability leave. It could happen, but the question always is, why did they let me go? Is it unrelated to my disability, or is my disability even part of the reason? If the disability is even part of the reason, it's illegal. But remember, either way, you are owed full severance. In fact, employees that have a medical condition or a disability are owed even more severance than employees that are perfectly healthy, because it's going to take the sick employees longer to find another job. All right, so a lot of things to discuss. Bottom line is, in any of those situations, if you lost your job, you call right away, pick up the phone, you email me, and let's discuss it. And of course, the contact information, as I've said, employmentlawyer.ca. All right, we're getting the best questions ever today, so I'm really happy about that. Keep them coming, guys. Love them. Next question from Fazilet, and I probably butchered the name. I apologize if I do. Please don't be upset with me. But Fazilet writes, can an employer give you an ultimatum to go back to work despite concerns around COVID, which is a risk for some of us who have health risks or live with people who are at risk? So your employer can require you to come back to work even if you have concerns about COVID, unless you have a doctor's note saying you cannot return. So Fazilet, if you have a doctor's note saying for medical reasons you can't go back to work right now, then your employer can't punish you, can't give you an ultimatum. But if you simply yourself feel uncomfortable, even though I completely understand that, I feel uncomfortable too, I get it. Unfortunately, despite you feeling uncomfortable, your employer can say you have to come back to work or else. If you don't go to work, that could potentially be considered a resignation or abandoning your job. So it's a question of, is there a medical reason verified by a doctor that says that you cannot go back to work at the office? Hopefully that answers it, Faizalet. If you have follow-up questions, type them in. I'll answer them right now. But you do need that doctor's note. For everyone else there as well, if you have a medical reason why you can't work, you need that doctor's note. Do you have that doctor's note? It's easy to deal with. Your employer has to follow what your doctor says, but you need that note. Again, employmentlawyer.ca to connect with me off air, employmentlawyer.ca. Great questions. I'm going to continue answering. From Joanna, she has a follow-up question. Can my husband still work at a new job if he gets fired and still file a case against his employer for wrongful dismissal? Well, your question was what happens if he resigns? If he resigns, he can't file a claim for wrongful dismissal because he wasn't dismissed. If your employer, if his employer lets him go, yes, he can still file a claim for wrongful dismissal. The value of the claim may be impacted potentially by when he finds another job, but we can deal with that when we know more details. But again, to your question, it doesn't seem like he may have a wrongful dismissal claim if he simply decides to quit and find another job. Okay, hopefully that helps. We have another question coming in from Tanya. Guys, I'm going fast here, but you guys have great questions, so please have them coming. I want to try to get to as many questions as possible during our session today. Again, we're live. I'm not here just to talk. I'm here to answer and to help. So ask your question. Next question from Tanya. As I said, my employment contract says that I cannot work for a competitor for 5 years. Wow, 5 years after employment. Is this legal? I work as an insurance broker. Well, here's the real thing you have to consider. The real question is not so much, is it legal? The real question, Tanya, is whether your employer is going to try to enforce it. Here's what I mean. The chances are that anything that says you can't work for a competitor for 5 years is not going to be enforceable, not even close. A court is not going to enforce it. But what happens if your employer, your current employer, tries to enforce it? That means that they'll sue you, they'll potentially sue your new employer, and they'll make your life very, very miserable. It's going to cost you a lot of money potentially. It's going to take a long time. So yes, you will absolutely win eventually, but in the meantime, it's going to be a very problematic for you. So the real question is not, is it enforceable? It's likely not. The question is, are you going to get into legal trouble or in a legal process if you ignore it? So my advice always, if you sign a non-competition agreement, talk to your employer, see if they'll release you from it. But generally, if you sign it, you have to be prepared to live with it. You know, my advice always is never ignore what you've signed. You can never sign something and say, who cares? That's not going to be enforceable, because you could be a part of a lawsuit. You will win that lawsuit, but it's not going to be something you want to be involved in if you can avoid it. All right. So hopefully, Tanya, that helps you. If you have any problems with that employer, if you have follow-up questions, either ask right now or contact me directly through employmentlawyer.ca. Again, employmentlawyer.ca. I'm going to continue answering. That's why I'm here. Next question, I think it's another follow-up from Mandel. Should you get a note from your family doctor to go on a medical leave, or do you need to see a specialist? You need a medical doctor, whether it's your family doctor, a specialist, walk-in clinic, doesn't matter. As long as it's a medical doctor that saw you and says you cannot work, if that doctor gives you a note, you can go off on a medical leave. Whether it's a medical leave for a day, for a week, a month, a year, you can get that doctor's note. It doesn't really matter. I mean, you can't go to your chiropractor or your physical therapist or your psychologist. It does need to be a medical doctor. But whether it's a specialist or family doctor, doesn't matter as long as you have something in writing from them. And remember, once you have something in writing from them, your employer can't really argue about that, can't disagree with it, can't question it. They have to do ultimately what the doctor says. Now, if what the doctor says is not clear, they can certainly ask for more information or for clarification, but they cannot disagree with your doctor. So having that doctor's note is a very powerful tool for an employee, okay? So there you go. Hopefully that answers it, Mandel. I have one more question here. I'm going to answer it right now, but please, we got some time. Ask your question. We're live, right? What's the point of being live if you're not asking questions? From Lori. Lori asks, if you are let go while on a disability leave if you're let go while on disability and let go the day you tried and do a return to work, how long is wrongful dismissal suit allowed if you unfortunately are still on LTD? So you can start a claim for wrongful dismissal the day you were let go. Okay, so you don't even if you're still on this on LTD, you don't have to wait to be off LTD. If your employer let you go, you can start a claim. Remember, you only have 2 years from that day, so you don't want to wait. But even if you stayed on LTD, if your employer says you're not coming back, we're letting you go, you can and you must start a wrongful dismissal claim at that point. Okay, that could also potentially be a human rights violation. So there's a lot of things that we need to discuss at that point. If you are in that situation, you know what to do, hopefully. Lori, you reach out to me through employmentlawyer.ca. Again, employmentlawyer.ca. See my email address, you click the button, you send me an email, phone number, you pick it up, you call me, no problem, employmentlawyer.ca. Wow, lots of questions today. Next question from Sinaz. Again, I apologize if I mispronounced the name. I was hired during the pandemic with no mention of an in-office situation. Now that Ontario is opening up, my employer is now saying it's an obligation, but I didn't agree to this. What are my rights? That's a great question. If you started working from home, if your employment agreement does not say anything about going back to the office, if there was no agreement that you go back to the office, they cannot make you. Meaning, if they do, you can consider that a constructive dismissal. In other words, by changing the terms of employment, changing from going from home work to in-office work, that's as if they've terminated your employment. Therefore, that means they have to pay you compensation, pay you severance. And even if you've only worked for the company for a short time, a few months, a year, you could be owed several months' pay. You could have worked for the company for 6 months. They could owe you potentially as much as 6 months' pay. So, Sinaz, if you've been let go or if your employer says you have to go back to the office, if you don't want to, then you don't have to, and that could be a constructive dismissal. But remember, that only applies to Sinaz because he was hired to work from home. He was never working in the office. If Sinaz had worked in the office, then during COVID had worked from home, his employer would be able to say, well, now we need you to come back to the office. But because Sinaz never worked from home, he always worked in the office, he always worked from home, not in the office, he never agreed to work in the office, then his employer can't make him. All right, so hopefully that helps. All right, next question from Darius. I cannot see Darius's question. It was pushed down my screen. Had very long questions here. So Darius, you can re-ask your question. Next question, therefore, is from Kathy. I was wondering if a company calls back a whole department in 100%, and then in the week they return, they tell all the employees in the department that they have to change all their days off. Is this legally allowed for them to do? Is that not a change to the terms of condition? We're not unionized. We have the same shifts and same days off for more than 4 years. So absolutely, if your schedule is being changed, that is a huge change to the terms of employment. So if you used to work Monday to Thursday and then had Fridays off, for example, and now they're going to change that so you don't have Fridays off, just as an example, that can absolutely be a constructive dismissal. So ultimately, Kathy, you have to decide what's better. Would you rather continue working with the new terms, or would you rather leave with your severance? If you want to leave with your severance, you can. Changing your shifts, your days off, your hours of work, your days of work, that's a significant change, and it's not a change that the employer is allowed to make even during COVID. So if you want to talk about constructive dismissal, reach out to me through employmentlawyer.ca. Darius's question was, how long will it take to get to mediation or trial at the HRTO? Unfortunately, right now it takes a long time because of COVID-19. Things are backlogged, so I don't even have the answer. It's a terrible system with the HRTO, or the Human Rights Tribunal in Ontario. That's why we try to avoid it and go through the court system as much as possible. Sometimes we can't do that, but I honestly don't know. It's going to take a lot longer. Usually it would be very quick to get to mediation, a couple of months. Now it could be a year or more. I really don't know, Darius. It's COVID has impacted that. It hasn't impacted our courts, but has impacted the HRTO. All right, next question. My gosh, one of the busiest sessions we've ever had with questions. I love it. From Ria. I was gonna go to vacation tomorrow. They sent me termination letter today. They give me 5 business days to sign the release letter. Should I ask an extension to have some time to talk to you or your firm? You cannot sign this letter before talking to us. Cannot, full stop. I'm not gonna allow you. Sorry, not allowed. Okay, can't do that. The reality is that your rights don't expire in 5 days. So you don't even need to ask for the extension. It doesn't matter, right? Your rights don't expire Friday. Your rights don't expire for 2 years. That said, out of courtesy, I always think it's a nice thing to say, I'm gonna take more than 5 days. I'm gonna take 10 days because I'm gonna get some legal advice. There's nothing they can do about that. Call us today, okay? Do not sign. I don't care what you think about it, what they tell you about it, what your Uncle Fred thinks about it. You cannot sign it without us seeing it. You see the number on the screen, you can call it or go to employmentlawyer.ca. You don't want to sign it and then find out, wait, they owed me another 6 months pay. Please don't let that happen to you, Ria. Call us, whatever you want, whether asking for an extension or not, it's up to you. But no matter what, do not sign without speaking to us. Joanna says, my husband disagreed with the performance improvement plan, so he cannot be fired. He can always be let go, Joanna, but they'd have to pay him severance. For them to let him go without severance, they'd have to show that, man, he did something terrible, okay? An employer can always let an employee go as long as they pay full and proper severance. So yes, Joanna, they can let your husband go. They can let him go because it's Wednesday and they feel like it, but they have to pay him severance. They're not going to be able to rely on a performance improvement plan unless your husband accepted it, unless he did something terrible. That's very, very difficult for an employer to do. Okay, so if they do let him go with or without compensation, with or without cause, have them call us immediately. All right. I think I am caught up with questions right now. So let me give you another address to keep in mind. Once we're off here, one of the places you can go to get some answers is pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. It's like having an employment lawyer with you at all time. One of the features there is our severance calculator. It allows you to find out how many months pay you are owed if you lost your job. So you go to pocketemploymentlawyer.ca, you click on our severance calculator, and in 10 seconds, you can get an assessment of how much you're owed. Whether you lost your job or are worried about it, it's easy, it's anonymous, it's free, there's no strings attached. So check it out. Frankly, the very first place if you go to, I think it was one of our previous questions was someone was let go. Well, if you want to know right now if the offer is appropriate, just go to pocketemploymentlawyer.ca. And it can do many other things as well, but our severance calculator is probably our most used feature there. So let's see. Let's continue answering a couple more questions. From Renata. My employer lowered my severance offer because I didn't sign after 2 weeks. Can the length of time you take to sign impact your offer? Nonsense. No, because the employer doesn't get to decide how much you get. The law decides that, right? So forget about what your employer did, what they want to do, what they think about doing. You call us. It's our job to make sure that you get proper severance. So think about it. Let's say they offered you 6 months. You're probably owed 10 months, and they're saying, well, we're offering you 6, but if you don't sign, we're going to pay you 4, but they really owe you 10. It's silly. Another example. Let's say I owe you $100. I borrowed money and I owe you $100. But I say to you, you better, I'm going to offer you $50, but you have to accept this by Friday. You'd look at me like I'm crazy, right? You'd say, well, why should I accept $50, Lior? You owe me $100. Well, it's the same with severance. It doesn't matter what you've been offered. It matters what you're legally owed. That's why we have to have that discussion. If you lost your job, again, reach out to me through employmentlawyer.ca. Okay, wow. I think we're all caught up on questions. It was a bit of a whirlwind session today. I love it. I will be back next week, so I'm not going anywhere. If I haven't gotten to your question, email me, call me, go to employmentlawyer.ca. I'll connect with you. My team will connect with you. We're available always, 7 days a week, all the time, to answer questions, to speak to you, to get you information, and to help you resolve your workplace problems. I'll be back next Wednesday, same time, same place. Please don't wait until then. If you have a question or a legal issue you need some help with, don't wait a week. It's never a good idea to wait that long. Reach out to me through employmentlawyer.ca. Again, I'm Lior Samfiru. Thank you very much for joining me today. I really enjoyed it. Amazing questions today. I'll be back next week. I'll talk to you soon. Take care. Bye-bye.